Welcome to today's event. My name is Camden Hutchison, and I am the director of the Center for Business Law at the University of British Columbia. And we are very proud to be co hosting today's event on business reinvention in an era of technological and institutional shifts. In the interest of time, I want to be very brief in my opening remarks. So I would just say that I think it is obvious to everyone that we are living in a time of profound social, technological, and geopolitical change. And I think the role of business in these changes is as important as it is fraught. So I very much look forward to the comments of our panelists today. And with that, I will turn it over to our panel.
Welcome to the opening session of our webinar series, Business Reinvention in an Era of Technological and Institutional Shifts. We created this series to foster a timely conversation about the role of business in today's zeitgeist or context, marked by rapid technological change, complex information and data governance challenges, and shifting institutional expectations that affect both society and the global economy. Our hope is that these discussions will not only engage everyone this Friday afternoon, but will also encourage us to think more critically, to be creative, and to work collaboratively about how organizations can adapt and lead in this environment. So we are delighted to begin the series with an panel. Roosevelt Giles, CEO of Stakeholder Impact Foundation, a serial entrepreneur who has served on the boards of multiple companies in the United States and internationally, many of which have a global reach. Professor Angela Daly of the University of Newcastle in Australia, author of several books, including Private Power, Online Information Flows, and EU Law, Mind the Gap, and another book, Good Data. And Gianna Giardini, a PhD student at the University of Camerino in Italy, whose research work explores emerging questions at the intersection of business, technology, and regulation. So welcome to all of you, and thank you for joining us today. And let me begin with you, Roosevelt. How can organizations reinvent themselves, particularly in their governance, risk management, and leadership models to remain resilient and competitive in an increasingly fluid operating environment? The floor is yours.
Let me share this slide here and get a background perspective. Thank you for inviting me. I'm envious of you all at the age that you are, and at this time in your lives and our history as to where we're going through these significant changes as relates to the corporate law and as it relates to the value of companies. And one of the things that is starting to drive companies and driving a lot of change is this slide. What you find today is that the value of the companies today, 90% of the value does not sit on the balance sheet. All right. So you think about that for a second. 90% of the value does not sit on the balance sheet. And because historically, companies' governance was centered around compliance. Okay, you check the box. You was compliant with the SEC and the FTC here in the US and other regulatory bodies. Now, with the shift to intangible assets, the companies value being affiliated with that. All of that is running on a technology underbelly. And so now we are shifting from the compliance governance to data governance, because data provides the value of the company today? And how do you go about managing the risk associated with that in an intangible asset? Well, the value of a company can fall significantly on one tweet. It's what can happen and wipe out trillions of dollars, all right, of value. And we see this almost on a daily basis. And so, therefore, when you look at from you all from the standpoint of the law, this is what you're going to have to contend with. Now, this particular slide here speaks to a U.S. based company, but you can also take a look at this particular slide, and it can also be ported, across the pond, to other locales. So in the middle of this is that when you look at the governance is nothing more how do you manage the contract between the capital and the management team, with the overseer, the agency being the board of directors. And so it's all centered around, those relationships are all centered around a contract. And that contract is the capital and the management team. And then you have these other parts, constituency parts here, your shareholders, your other equity holders, your stakeholders, all right, is what you have. And here in the US, we're still wrestling with shareholder primacy and stakeholder primacy and things. What we're still wrestling with the rest of the world pretty much is on the stakeholder side of the house. And that's where I am, there in that particular category. And so you have all of these constituencies, different types of shareholders that you owe fiduciary duties to. And as a law professional, your job is going to be, how do you keep your clients coloring in between the lines so that they do not encounter a risk in having to deal with an action, litigation against the company? Your job is to keep them out of that space, is what your job is. And when you look at from the perspective of a board, most of the time we start talking about fiduciary duty. And people throw that term around just flippantly, is what they do. But fiduciary duty is nothing more than a gap filler. That's all it is. Because if you think about it from this way, think about from the standpoint that if you all have studied, some contract law and things, that when you form a company and you create the articles of incorporation, the bylaws, there's no way that you can contract for the future on what the future state will be and what some great engineer, programmer, AI agent is going to go and do. You have no idea. So you can't contract for that. And so fiduciary duty says that when you can't do that, it fills in the gaps. It fills in the gaps, and then it goes back and references my articles, then in my bylaws. And again, here in the States, we have the Delaware law, which is the pole position right now, but that's being challenged. And I don't know in your law, where you are you teaching Texas law, Nevada? Well, Nevada and Texas is getting in the game now as a term called de-exit. De-exit is real. And when you go to a law firm, especially around corporate law, you're going to encounter it, because that is talked about a lot in the boardrooms today. And why is that? I say, well, why is that when Delaware have all of this case law and it is predictable, and you don't have juries and things. So why would you want to upset that? Go back to what I said earlier. Governance has changed. We have shifted from compliance governance to data governance. We got cyber, we got AI, data transformation. Those technologies, even though they create the value, also create risks. And if something goes south, and I, as a board member, have breached my fiduciary duty, where do I want that litigation to take place that will benefit me as a director in the company? And those are the decisions today that boards and the management teams, okay, are evaluating. Because Texas and Nevada is a much lighter, okay, on the directors and the management team somewhat than Delaware. And given all of the cyber breaches, hallucinations that's going to be appearing with AI, lots and lots of derivative lawsuits going to be filed, where do you want those cases to be held and filed? Delaware, where it's a little bit more stringent around entire fairness doctrine that Delaware has. You know, you start with the British judgment rule, entire scrutiny, and then entire fairness. And it gets tighter. Those bands get tighter as you go up the loop as to your liabilities, okay, and your ability to be able to get these things thrown out on the pleading stage, right? And so this chart represents what you will have to address with your clients when you go into this field in helping your clients navigate this. Because courts, what I have found in being in court and been sued, courts don't care about the technology. Courts only care about your process and structure, period. They do not care. Process and structure. And one of the things that you will do is to assist your clients to document for that time that there will be an action against the company. And you want it documented such in the process and the structure so it will get thrown out in the pleading stage. So as a young lawyer, that would be a major focus because I know we spent a lot of time in it as a board. And I had a board meeting just a few seconds ago and coming here. So taking those things into consideration and understanding the differences between those jurisdictions, again, here in the States, you become a trusted advisor and a partner to that organization. It's what you become. The other thing, shareholder primacy, stakeholder primacy. This chart also addressed that because there's still a lot of noise and things around that. And one of the things that people are wrestling with today, and I find it interesting because a lot of people still believe that shareholders own companies. Shareholders don't own companies. Companies own themselves here in the US. Shareholders just have a contract, and that's a share of stock is what they have. But a company owns itself. And the board's job is to maximize the value of the entity, meaning the corporation, for the ultimate benefit of the common shareholder. So the first instance is to the company for the benefit of the actual shareholder itself. So it gives companies and the teams the flexibility on how they're going to manage and allocate the capital. It gives them a lot of flexibility on that. Because when you look at a lot of case law, you do not see in case law where the courts will make a board to put shareholder primacy first. They will not do that. I've never seen a case at all. But that's what permeates today and drive a lot of organizations today is this shareholder primacy. And again, that is something that you will be encountering is what you will be encountering about.
Roosevelt,
So
let me
I'm going to pause there for a minute. So for the questions.
thank you for that, Roosevelt. I have a question. So you are saying that companies operate right now within this contractual framework, essentially between shareholders and the board members. Is that correct?
Right.
And can you give us examples based on your experience? And I don't want you to disclose any private conversations that you have had on boards, but can you please give us examples that show that companies are reinventing themselves in a context where information is so complex right now? Can you give us examples of that? And in that context, is there any space to think about stakeholders or it doesn't matter? Is it just a question of trying to maximize profit, thinking about shareholders within this contractual context, trying to reinvent themselves, considering the information complexity that we are dealing with right now?
Yes, what you're finding now is the fact that again you go back to the the fact that the value of the company being intangible assets, right? Well, most
Mm-hmm.
of that have to be people. All right. So that's your brain trust that goes down the elevator every day. And so how does one go about if you do not have a culture, all right, within that organization, which is driven down from the board to the management team and then out into the company, you won't be able to attract the talent that you need in order to take advantage of those intangible assets. You will not be able to do that. Because one of the things that we have our students in the fellows in our board readiness program that we teach, we ask them on the public companies that each one of them get to be assigned, take a look at the number of patents that your top three competitors, okay, have filed over the past 3 years. And it is striking to see in their various sectors, in their major competitors, you might have your company files 75 patents. Your second tier competitor, 110. The top one, 200. Now, what does that say about the culture in the organization? It tells you a whole lot about that culture within the organization. And that culture starts at the board and filter down within the organization. Because again, the company, the CEO serves at the pleasure of the board, right? CEO can't tie the shoes without permission on the board. That's just the way it is. So in order to take advantage, excuse me, of these technologies today, boards also are refreshing their skill sets. They're bringing in younger board members who are digital natives. They understand digital, is what they understand. Because if you go back to what I said about compliance governance, those directors who came on boards back, 20 years ago, the risk was totally different, completely different. So the risk now has changed 100,000% because every company today is a technology company. I don't care, it's a lawn service, it's a plumbing company. Everything is running on a technology underbelly. And so you have to take that into account in your governance and the way in which you can now attract talent. Because we have a talent race today, is what we have to get the best talent. Even though we have all the stuff in the news around, the layoffs and what AI is going to do and all of that. I've seen these before. That's what I've seen. But again, I'm not belittling it because it is going to be so transformative. I mean, phenomenal is what it's going to be able to do. But the only way you're going to be able to harness it is that you got to have the right people, the right board, and that board has to pick the right management team. And then the board and the management team have to pick the right outside counsel, the right inside counsel, so that they can assist that company and just keep them coloring between the lines. Don't go outside the lines, color inside the lines such that you don't have to deal with. And that, you can never get away from litigation. That's just fact of life. But if it does happen, 80% of the time and 90%, it gets thrown down in the pleading stage. All right. It will happen because you have a good grasp of it as well. I would also recommend this. I would recommend as attorneys to really, really understand governance. Okay. Really, really understand that so that you can teach your clients, help teach your clients and things there as well, because that is so important. Okay. In order for them to stay out of trouble.
Roosevelt, I have one final question. What is different now in terms of technology and evolution? Because new discoveries have always existed. The discovery of the wheel, fire, and so on. So isn't this just a new stage in humanity's development? What's different? What makes us pause right now in 2026? And a follow-up question, where is corporate governance going? How do you see corporate governance in the future? Because we've come a long way since early 2000s, right? Where when corporate governance was just, rising and becoming this very popular field. So where do you see us going in terms of governance and why is this new?
Well, when you look at, I got into technology in 1975 when I graduated from University of South Carolina in Limestone and business and computer science. And I programmed in assembly language and C programming and PL1 and all of that stuff. And I went to work with Bell Laboratories, and in 1988, I was working with machine learning. And it had been in Bell Labs there for the 70s. All right. That formed the basis of what we're seeing today with LLMs. All right. I also authored a couple of books on protocols, how you move data across the network. Is what I authored back 27 years ago. And that technology is what is the backbone today that carries all of the bits, the zeros and ones across the internet. All right. With AI and everything else, okay, affiliated with it. Technology goes in cycles. All right. The other reason that we're here today is because we have inexpensive chips, microprocessors that are very, very powerful. You think about this iPhone. You think about that thing. Think about when they first landed on the moon. This thing is 1,000,000 times more powerful than that spacecraft that landed on the moon that we have in our hand. Okay. And so having this technology and being able to harness this technology to be much more productive, okay, much more productive, then therefore you start to look at as to how companies will deploy it. I think that companies are making a big mistake in not communicating to their people on how AI will impact the organization, and that will be some restructuring, okay, associated with that, because we have this thing called competitors, customers, okay, it's what we've got. And my thing is that to show them a path, a a soft landing. And that's where you partner with vocational schools, technology schools, so that people can get retooled. All right, it's what they can do. And so now I have this soft landing, and look at what it does for the company. Yes, I was restructured out, but look what the company did for me. Okay, that's what you want. Because right now, companies are having a very hard time with employee engagement. Mm-hmm. Over 60% of the people, they're not engaged. Look at what it's costing companies. Billions of dollars on an annual basis. And what CEO and what board would want that? I am in the camp and along with other CEOs and board members that we have to communicate, because right now, people don't trust companies. Employers don't trust them because management has a contract. They have a soft landing. They have a contract. Management tells employees, trust me. I have a contract. I tell you to trust me. That's not an alignment. Not an alignment at all. So in order to take advantage, again, of this intangible asset, you must treat the people and attract the right people. Otherwise, you will not exist. And this technology is such that today, you're number 3, tomorrow, you're acquired, you have to go merge for another company, or you're insolvent. That's how this technology accelerates those companies who are run well and those who are run bad. That's what this technology is doing. It's accelerating mergers and acquisitions. It's accelerating bankruptcies. It's what it's accelerating. So there's no right or wrong answer, but it all starts with, and that's why I spent a lot of time on getting the right people in the right seat on the board of directors. That is so key, because nothing happens. Nothing happens unless you got the right person in the right seat.
This takes me to think about the European context, because you were talking about communication between the board and people, in particular employees and other stakeholders. But it sounds like you are coming from a place where a board of directors and directors themselves can make that choice. But if we think about the European context, and I'm now looking at Jana, things are not that easy or free, because the regulation and the regulatory philosophy is very different. So Jana, could you please step in and talk to us a little bit about what's happening in Europe from your perspective?
Yes. Let me share my screen.
And Jana is in Italy, in Camerino. Is it Camerino right now? Yes? Okay.
Yeah.
Good.
First of all, thank you, Professor Vicente, for the invitation, and thank you to the University of British Columbia. Let me briefly introduce myself. I'm Gianna Giardini from the University of Camerino School of Law. I belong to a huge, big group of researchers engaged in the energy transition under the leadership of Professor Lucia Ruggeri, who is a full professor of private law at University of Camerino, but also director of the School of Law. We are deeply engaged in the energy transition, and in the last year, we carried out 2 important projects with remarkable impact in terms of scientific outputs on energy transition. Personally, I have I'm concluding my PhD pathways. Last week, I delivered my thesis, and despite the defense is foreseen in May. And during my PhD in sustainable development and climate change, I carried out a research on the energy transition of public authorities, or better, I tried to investigate in which way private law models, because we are privatist, can drive and foster the energy transition of local and public authorities, with particular focus on energy community. And today I would like to bring to the audience, to reply your question, Professor Vicente, I would like to bring my expertise in the energy market, because I think that energy market could be considered as a clear example of adaptation of the market to institutional shift, but also digital transformation. In European Union, the structural reform of the electricity market started in 2019 with the Clean Energy for All Europeans package. What foreseen European Union? The European Union tried to design a new energy governance in which citizens are active market participant with the right to produce, store, sell, but also sell energy. And this new governance of the electricity market enabled also the emergence of decentralized and collective models. But how has been it possible? Thanks to the digital innovation. And so I try to reply to your first question, because the democratization of the electricity market in European Union has been made possible thanks to the digitalization, because technological advantages, particularly in renewable energies, have enabled a significant transformation in the way energy is generated, and led in the meantime to the emergence of decentralized and distributed production and consumption model. And this model have enabled greater market participation by all the consumers, and make possible also the emergence of new legal and business model as energy community. So in the electricity market, digitalization could be considered as a precondition of energy democracy. But what are basically energy community under the European Union framework? Energy community, renewable energy community, and citizen energy community are legal entity, private law legal entity based on the open and voluntary participation of citizens, small and medium enterprises, and local authorities. But the particularity of energy community are that energy community aim at producing environmental, social, and economic benefit rather than financial profit. In the EU legal framework, we can find renewable and energy community and citizen energy community. The framework is the same. The difference is that in case of renewable energy community, the electricity is generated by the renewable sources. Instead, in case of citizen energy community, the electricity is produced both from renewable and not renewable sources. But what are energy community actually? In my interpretation, but my interpretation perfectly match with the interpretation of the European Commission, energy community are enterprises. Energy community could be considered as market actors. So because energy community provide professional participation in the electricity market, but with an important social impact. So energy community has to compete on a level playing field with other market operators, can attract public and private capital, can generate economies of scale, but the distinctive element of energy community is that social impact has to consider the purpose, and the purpose is the maximization of collective well-being and also the promotion of shared goals beyond profit. The structural feature of energy community, the membership. Energy community has to be open to small and medium enterprises, people, local authorities, and there are important limits in the participation on dominant actors. Investment, voluntary participation, and not speculative capital logic, but also the governance, because energy community search for autonomy from powerful market actors, but in the meantime, the members of energy community has an effective decision-making powers. We discuss about activities, so production, sharing, and management of renewable energy, and the distribution of benefit is the last but not least a structural feature of energy community, because energy community aim at producing environmental, social, and economic advantages. So energy community respond to a specific vision according to the European Union legislation, that is not only to reduce energy bills or contribute to decarbonization, but also to create a new ideal of community in which people, enterprises, local authorities contribute to the development of the territory in which they operate. Because in case of energy community, the revenue could be have to be must be reinvested in the territory in which energy community operate. So from the point of view of the normative principle, because we are lawyers, we have also to discuss about principle. First of all, energy community is an expression of a principle of subsidiarity, because they aim at reach a decentralized and participatory governance with strict local dimension, but also energy community are an expression of principle of sustainability, because they integrate SG logic by definition, economic, social, and environmental profit. Energy community are also an expression of competitiveness, because in case of energy community, there is a principle of open door. People can enter and exit whatever they want, and they can also, for example, also for convenience. And so energy community respond to a logic of competitiveness, but overall solidarity, intended as a duty of cooperation and good faith between the members and active citizenship. So to conclude and also to reply to your question, when we talk about energy community, we can really talk about a new paradigm of transformation. Energy community determine a reinvention of business, because we discuss about a new decentralized production model, new collective market actors aim at creating hybrid value, economic but social impact. There is a strong reconfiguration of leadership, because the electricity market go from centralized and vertical utilities to distributed governance, in which are involved also citizens, and citizens are co-producer and decision makers. And so energy community represent democratic transformations thanks to the implementation of a principle of subsidiarity, active citizen, and solidarity. And I go to the conclusion, in the case of energy community, digitalization, the democratization of the energy market has been made possible thanks to the digital transformation with smart grid and peer-to-peer exchange. So in case of energy community, the technological development could be considered as an enabler of energy democracy. Thank you.
Thank you so much, Jana. That was really, really good, great. I have a couple of questions. First, I start with a comment that Roosevelt and Jana basically said that what we are seeing right now, or at least the steps that we have to take forward, will be linked to people. It all boils down to people and considering people. Jana was talking about energy communities. Roosevelt talked about employees and how the board approaches that constituency. So that is an interesting takeaway from both of your presentations, considering that you don't know each other and you have not talked to each other. So that's a nice thing. The other thing that I feel needs a little bit more clarification is the connection between digitalization and democracy. Because typically what we hear is that digitalization, and not only that, but social media and all this new technology is impairing democracy. But what you say is that in Europe, digitalization and new technologies have been used to promote a sense of community and integrate principles or democratic principles. Can you please tell us a little bit, possibly with an example, a concrete example that shows how digitalization is able to do that? And the other point, the third point is, what is the principle of subsidiarity? Because I know that is connected to the way the EU works, but here in the United States, we have federation and states are independent to a certain extent. And so could you please clarify us and those who are at home listening to us what that principle is and why is that so important?
Yes, about your first question, I think that says that digitalization is a driver of democracy, is a strong concept, but it's true because you have to think that until now the electricity market was a sort of vertical market. There was this distribution system operator and then consumers. With the digitalization, we are trying to develop the smart grid, and so the consume is basically an exchange of data, what you consume and and the energy that you can generate. And in this way, people, person, enterprises, local authorities can manage their data and they can participate to the market because there is a sharing of data, the energy that you produce and the energy that you can consume, and also the capacity to understand in which way the market work thanks to digitalization make possible also foster democracy and the possibility to participate in a market that usually is intended as a very strict market. And about your second question, the principle of of subsidiarity. In case of in the Italian legislation, the principle of subsidiarity is in our constitution. We have to distinguish between vertical subsidiarity that deal with the allocation of the function between the different level of governance, for example, national, regional, and also level of municipality, and horizontal subsidiarity. In case of energy community, we are talking about horizontal subsidiarity that means the possibility for citizens to participate in the implementation of general interest. Because in the case of energy community, people could be able to satisfy their own needs, but in the meantime, with the revenue of energy community, they are able also to generate environmental and social benefit for all the community. So in our case, the principle of subsidiarity is in the constitution. In the case of a EU framework, the principle of subsidiarity is in the treaty. But from a European perspective, the principle of subsidiarity is considered also as vertical subsidiarity. So the allocation of the function between the different level of powers. Instead, when we talk about energy community, we are talking about horizontal subsidiarity, intended as the ability, the capacity of people, third sector, to participate in the implementation and satisfaction of the general interest.
Thank you so much. I must say, I have to disclose this. Jana was my student, and I'm so proud of her right now, because I think your presentation and your clarifications were brilliant. And I hope that those who are at home are able to grasp a little bit of what is going on in Europe from your perspective, which was great and is great. So right now we have Professor Angela Daly, who was kind to share with us her presentation. She is in Australia, so it is very early for her. But Christian, could you please play her video?
Absolutely. Let me know if this comes through.
Hi everyone, my name is Angela Daly and I'm Professor of Law at the University of Newcastle in Australia and the University of Dundee in Scotland. I'm sorry I'm not with you live today, but I'm in Australia at the moment and the time difference is a bit too difficult. So I have recorded my presentation, and if you do have any questions, please feel free to email me. My email address will be at the end. I'm going to talk to you today about the regulation of big technology companies and contrast the approaches in the European Union and the United States to this topic, and talk a bit about some of the recent interactions between the EU and the US on regulation. So to give you an overview of my talk, I will start by outlining those regulatory approaches to big tech and pointing to how they compare and contrast with each other. Then I will look at the recent tensions between the European Union and the US on this topic, before proceeding to talk about two responses to those tensions from the European Union, so in the form of the digital omnibus proposals and also in the EU's move towards digital sovereignty policies, which in some ways conflict with each other as well. And then I will conclude with some thoughts on this topic and on the role of global corporations. Okay, so looking first at regulatory approaches to big technology companies, and by big technology companies, I mean in particular talking about those that originate in the US. We also do have a few that originate in China as well, but in particular, the ones that I'm referring to are Google, Amazon, Apple, Microsoft, Meta, all of which are US based US headquartered companies. And these are also very widely used in the European Union. But I think to start with, it's important to understand the general ideologies underpinning the regulation and the regulatory approach of the European Union versus that of the US. So in general, although it can be contested and it doesn't always conform to this, however, the European Union in general adopts a regulatory approach which could be termed the social market economy. So the European Union regulates its companies, its economic sectors in a way that seeks to achieve certain social, economic, and environmental outcomes, and in some ways can be quite interventionalist in order to do that. This can be contrasted with the approach in the US. I'm sure you probably know it much better than I do, and it does also differ from administration to administration in some respects. Under the current Trump administration, some have pointed to the US's current approach as being neo-mercantilist, so in a way that seeks to consolidate the economic power of the United States and seeks to boost exports and reduce imports. And that is how some have read the activities around tariffs, for instance. But the US generally is less interventionalist when it comes to big technology companies compared to the European Union. It's also the home of most of the Western big tech companies and an artificial intelligence superpower as well that many of those companies contribute to. And the main technological rival for the US is China, not the European Union. The European Union mainly uses digital services and technologies that are developed and created in the US and China, and doesn't really compete so much on this itself, despite its attempts to boost its homegrown digital services and technologies. In contrast, the European Union, it's not a technology superpower like the US and China, but has sought to use its position as the world's largest trading bloc to position itself as more of a regulatory superpower, not so much a technology superpower. Having this status as the world's largest trading bloc does give the European Union some power to enforce and export its regulations to other countries, particularly those that are economically weaker than the European Union and that seek to trade with it. The European, and this is known as the Brussels effect, coined by Anu Bradford from New York University. And in particular, we see with data protection and privacy laws, the Brussels effect of the general data protection regulation of the EU has been quite important. So various other jurisdictions outside the European Union have adopted data protection laws modelled on the European Union's General Data Protection Regulation. This can be contrasted with the US. As I'm sure you know, there is no federal privacy or data protection regulation in the US, nor is there federal regulation of artificial intelligence. And again, on AI, this contrasts with the EU, which has recently finalised and has started to implement its major regulation of artificial intelligence, the AI Act. The European Union has also been active in antitrust in digital markets in the form of the Digital Markets Act, which supplements its previous antitrust laws, which were broadly in line with US antitrust laws. This Digital Markets Act imposes additional obligations on certain very powerful, dominant players in the technology market. On antitrust, there's probably more alignment between the US and EU, but this Digital Markets Act does go further than US law. Where I think there's much less alignment is around speech, particularly under the current US administration. Various concerns have been raised there about content censorship on platforms and in particular the Digital Services Act in the European Union, which seeks to regulate online platforms, has come under quite a lot of criticism, as it does, or it can involve removing content that is illegal from those platforms. I think it's also important to note, as you may well be aware, that in general, the US and the European Union have quite different approaches to privacy and free speech. Privacy tends to be protected more in the European Union and in individual European countries through constitutions, for instance, and freedom of speech tends to be somewhat more restricted than the First Amendment in the United States. The First Amendment tends to protect more speech than would be protected, or more kinds of speech than would be protected in the European Union. And behind this are it's kind of the history, culture, cultural differences and historical differences and legal differences, which have led to different approaches on these topics currently. So that there's a big contrast on both of those issues in the European Union and the United States. Okay, with these have led to various kind of tensions with regards to the interaction of the European Union and the US, particularly as regards the trading relationship. But it's also acknowledged that the European Union's competitiveness, it is declining compared to that of the United States in terms of its economy, its economic competitiveness. And the Draghi report on the future of European competitiveness identified bureaucracy in the European Union as regulatory fragmentation as being behind this decline versus what is happening in the US. In addition to this, the second Trump administration has criticized some digital laws in the European Union very specifically, such as the Digital Markets Act and the Digital Services Act. And this has played into the debates around and activities around tariffs, so trade tariffs that have been placed on the European Union by the Trump administration, and agreements around those tariffs last year as well. Although I think more tariffs have now been imposed, and I don't know if anyone is entirely sure what the current state of play is. But in those negotiations, the US government has identified the European Union digital laws as being, in its view, too restrictive of US technology businesses. And even there are policies discussed at the moment in the US, such as the freedom.gov portal, which would seek to circumvent various restrictions, such as those in the Digital Services Act in the European Union. So the regulatory divergences and ideological differences are really playing out with regards to this tension and in the discussions around tariffs. Okay, so how is the European Union responding to this? Well, as I mentioned at the beginning, I think there is some tension in its response. On the one hand, it is proposing the digital omnibus regulation, but on the other hand, it's also pursuing policies that, to me at least, would seem to be quite different or going in a different direction. But starting with the digital omnibus, this is a proposal to amend various European regulations which would impact on technology companies' businesses, including the GDPR, so on data protection, and the European Union's AI Act. And the omnibus proposal seeks to reduce overlapping obligations in these laws, so streamline them so it would be easier for companies to follow and to comply with these obligations. But it also seeks to reduce the level of, for instance, privacy protection that the GDPR offers, and the extent to which AI is regulated, particularly from a safety perspective. Now, of course, these proposals have come under a lot of criticism in the European Union. They're viewed as being deregulatory and also serving the interests of business, but particularly big business. And in addition, viewed as being kind concession to the US government by the European Union, which may assist its negotiating position on trade matters. As I mentioned, that's one response by the European Union, which would be to seek to deregulate more and in that sense align more with the US approach to regulating technology. However, there's another policy that the European Union is pursuing around the notion of digital sovereignty. And in this sense, digital sovereignty is taken to mean the European Union reducing its dependence on foreign companies, so perhaps moving into a more neo-mercantilist approach itself, and in particular on technology coming from the US and China. As mentioned before, that's where much of the technology and digital services that are used in Europe, that's where they come from, and there's not so much homegrown technology and services. So these are policies and policy discussions at the moment on the whole rather than laws, but there seems to be a growing momentum around creating, for instance, what is known as what is known as the Eurostack, which would be a whole kind of suite of digital infrastructure products and equipment that would be made in Europe and created in Europe and would allow the reduction of this dependence on foreign technology companies. But there is one piece of legislation, again, that's currently being proposed along these lines, the European Union Cloud and AI Development Act, which would seek to expand the infrastructural capacity of the European Union with regards to cloud and AI services, and therefore seek to increase the digital sovereignty of the EU. Okay, in conclusion on all of this, I want to offer a few thoughts about what is happening. So from the European Union perspective, it is not entirely clear what the European Union, or there's not a kind of coherent approach from the European Union on how it is going to proceed with regards to technology regulation. It's the digital omnibus on the one hand, as mentioned, would reduce the protections in some of its laws, be more in line with a deregulatory approach, and perhaps also allay some of the concerns from the US government around what it sees as the overregulation of US-based big tech companies. But is this really in line with what the European Union wants? And I think it raises questions about what kind of model of regulation and what kind of digital innovation does the EU want, and who are its regulation and policies serving? Are they serving big businesses, especially transnational businesses outside of the European Union? Are they detrimental to the small and medium enterprises that characterize many European economies? And in addition to this, I think there shouldn't be this binary tension between innovation and regulation that, that regulation is in itself bad for innovation. I think the question is more what kind of innovation does regulation shape, or a lack of regulation shape? And I think these questions need to be better understood in Europe, at least. I think we also see with regards to the trade discussions around tariffs and how things like technology regulation in the European Union are being brought into those discussions, a possible Washington effect. So as mentioned, the European Union has enjoyed this Brussels effect, particularly with regards to other jurisdictions and trading partners in the past, that it sets its own rules and others tend to follow because that's advantageous for them to trade with the European Union. But here, I think the European Union has come up against a US government that is seeking to promote its own interests, of course, but also its own approach to regulation vis-a-vis Europe, and that may be dulling the effect of the Brussels effect. And with regards to the role of global organizations in such kind of flux, what I would observe is that if we conceptualize the big US-based big tech companies as global corporations, which they are, at least in my opinion, I think they absolutely are. I think we're seeing their role in shaping regulation. On the one hand, they're very active in lobbying in the European Union, in Brussels, to when the law and policy making processes are occurring. But on the other hand, they also seem to have strongly aligned with the US government, and the US government is seeking to promote their interests as well in for instance, the trade discussions with the European Union. So they are active in shaping regulation through different means, and that is one way of them weathering the uncertainties that we see internationally at the moment, and probably for the at least near future. Okay, that's it from me. Thanks very much for listening. And if you do have any questions, or comments, feel free to reach out to me at my email address. Thanks.
All right, so this is all for today. I would like to thank our guests. So, I mean, this was a truly global meeting with accents from Georgia, Atlanta, Italy, Canada, right in the center of the world, Kansas. So thank you so much, and I'll see you next time. Thank you.
All right. Take care.
Thank you.
Bye.